Good morning, and thank you for joining us for today's Workers' Compensation 202 webinar. I'm Allie Price from the Board's Stakeholder Engagement Unit, and joining me today is Joe Cavalcanti, the Board's Advocate for Injured Workers. Today, Joe will take a deep dive into the best practices workers can use to access their workers' compensation benefits, including understanding labor market attachment, details on benefit periods and how benefit rates are calculated, the importance of items such as the degree of disability and the carrier continue payments, CCP order, how advocates can help workers and comply with privacy provisions and the Workers' Compensation Board's New York Medical Treatment Guidelines. We will be taking your questions via the chat today. You may enter your questions throughout the presentation in the chat box located on the right-hand side of your screen. Joe will answer as many of your questions as he can, but if there are any that he doesn't get to, or if you think of something after the session ends, we will be providing you with additional resources at the end of the presentation. Your name and email were given to us when you registered. However, if you have a specific topic you'd like to discuss more in depth with the board, please share that topic along with your contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are set so that only panelists can see your questions or comments that come in, so do not hesitate to put questions in because they'll remain anonymous. With that, I'll hand it over to Joe, and we'll get started today.
Thank you, Allie. Good morning. Welcome to my and Allie's first educational webinar of the summer. Yes, my friends, we're in summer now. This is the 202. We use the college naming model here. That means that this is building on the intro, which we call 101. Well, guess what? If you missed the intro, we're doing one tomorrow. Allie and I will be back tomorrow at 11 a.m. The intro is a little shorter than this one. So if you'd like to join us on that or refer this information to someone else, please go on ahead. Just come back to our website and click register, and we'll see you tomorrow. Okay, the Advocate for Injured Workers. Technically, that's me. That is my my honorific title. My civil service title is actually Ombudsman, as you see on that first bullet. What's an ombuds? Well, we're a role that is in certain types of institutions because we're there to ensure the health of the system. We're there to ensure the sanctity of the system. That's what I'm here for. We have another ombudsman called the Advocate for Business. Okay, we're both ombuds. He does webinars too, by the way. So the Advocate for Injured Workers, me, I have an office of people, and we help workers with the more difficult claims and the more complex claims, and we are also involved in fatality claims because, of course, as you probably know, there is a very important fatality benefit in this system. And along those lines, because it's been so devastating, I work directly with the 9/11 community. My friends, that situation is still ongoing if this is news to you. So we're going to pause for a moment because I would like to point out a couple of things. I'd like to talk about the three primary modes of assistance that people have in World Trade Center. You can see on your screen there from left to right. World Trade Center Health Program. These are the medical and health programs that are funded by the federal government that are provided at no cost to World Trade Center responders and to people who survived the initial attacks. So if this is you, I can't urge you strongly enough to get into the health programs and at least get the free expert medical monitoring. In the middle there, you see the September 11 Victim Compensation Fund. Well, the federal government provides compensation to people who suffered physical harm or economic loss or who lost people as a result of those attacks. So that's through the federal government. I'd also encourage you to visit that website and learn more. And finally, yes, workers' comp. It's for paid employees. Everyone knows this? Well, the World Trade Center is the one place where volunteers can have a workers' comp type benefit. And that's administered by the board through the World Trade Center Volunteer Fund. Okay, so we have some information there for you as well. And finally, the last thing of note here is that I report directly to the chair of the board, the head of the agency. That's a feature of an ombudsman type role because you can't report into the people who you might, want to make some suggestions to. All right. We have education. Dun, dun, dun. This is a specialty of Allie in her unit. Yes, it is. And also, before I was the ombudsman advocate, I was in that unit too, so I know all about these publications. We are urging you to visit our website, wcb.ny.gov, and go down to the bottom of the page and click publications, and you'll see something that looks an awful lot like this. We have publications for workers, for employers, we have annual reports, we have so many important good things there that you will benefit from reading. And by the way, you might notice we have these publications pre-prepared in the 12 languages that more than 90% of New Yorkers speak. And if you needed it in another language, we would give it to you. Let's say you're a worker. Let's say you're an advocate for workers. Either way, do you have access to eCase? Do you have access to your own claim folder? Well, we suggest that you get it because then you can see everything that's in your claim folder the same way we do and any other claim professionals in the process. So, Allie is kind enough to show us the web page where you register. This is how, why don't you give that a click, Allie? Let's show them how easy it is. This is all you need to provide to get access to your eCase. If you're an injured worker or if you're an advocate who wants to help injured workers, well, we're going to cover how you can get this access on the next slide. But anyway, point is, here you go. This is all you need to do to get access. Now, the next slide here, we're going to now show you the privacy provisions of the comp system. Okay, this is for workers who sometimes might ask their spouse or parent or, really knowledgeable cousin Vinny to call in on their behalf. I'm sorry, there are privacy provisions in the comp law, not in HIPAA. We don't use HIPAA, although HIPAA is always there, and you might need a HIPAA release at some point for something. But we use the comp law, and so the only parties that the board can discuss a claim with without a special release are right there on screen. Workers and their attorneys, employers, insurers, their attorneys, and providers, healthcare providers. Okay, if there's somebody else, well, the worker is, assuming the person wants to speak up on behalf of the worker would have to grant access. Actually, yeah, the worker would have to grant access to anybody, yeah, to the file, and here is the form that the worker would complete. The form is known as the OC 110A form, okay? Very simple, it's the top, who are you, what's your identifying information, and then at the bottom there, you're going to identify who can hear details of your claim. This does not need to be notarized. That was not notarized, okay, so it's pretty simple. You just need to return the original. That means you can't fax it in, you can't email it in. You're going to need to return the original piece of paper, and then we'll get it in there in your file. You can complete it online. You're going to have to print it then. And there's a Spanish version that's readily available. If you need a version in another language, if we don't have it, we'll get it. But we call out the Spanish because I don't know if you realize this, but more than 76% of our translations are Spanish. Yeah, so it's that prevalent. All right, now we're going to get into the benefits. there are two primary benefits in comp. There's the medical care, and then there's the lost wages, or what's known indemnity. It's known as indemnity. So in this webinar, we devote more attention to the indemnity benefit due to the complexities therein. So we're going to start there. Controversies. It is possible for the insurer to formally dispute the claim right from the top, right from, the first days. They have a period of time when they can do this. If it is formally disputed, the technical term for that is controverted. Okay, you see how it comes from the word controversy? So, if that happens, no benefits are going to be paid while the controversy is being resolved. So at the end of the controversy, there's going to be a decision made by the board, either establish or disallow. If a claim is disallowed, it's not allowed. It wasn't a valid workers' comp claim. All right. The process is probably going to take 90 days or less. We have something called an expedited calendar. We've had this since the 2007 reforms. This solved a major system problem back at that point in time, so this is very good stuff. So most of the disputes are going to be on the expedited calendar. There are some disputes that are just too complex to put on the 90-day path. And the most obvious example there is an occupational disease. If it's claimed for an OD, an occupational disease, it's going to probably be too complex to go in this route. The insurer can dispute the claim and controvert, but they have a list of reasons they must select from. Okay? It's 16 or 18 reasons, and those are the only reasons they can do, and they're not allowed to just click all. All right? They have to be specific. Now, injured workers, here's something you can do if you should be controverted. You may, if you're missing time from work, okay, if you are injured to the point where you can't work, you may file for short-term disability. Because disability, short-term disability, is for injuries off the job. Well, we don't know where your injury resulted from at this point in time, so you may file for disability. Allie is showing you the DB 450 form right now, which you can get off our website. If you're eligible for comp, there's a high probability you're eligible for short-term disability. It's not 100% though. You need to check it. For example, if you work for New York State government and you get injured, we're not covered by short-term disability like this. But we have other protections. So what I'm saying is you can file this if you can't work, and at least you'll have some income. You'll have the $170 a week that is provided under this plan for up to 26 weeks. There is an order that a judge can do that is known as carrier to continue payments. The shorthand is CCP. Okay, we're a system that loves acronyms. I try not to use them, but I'll explain them to you. If you ever see CCP, carrier to continue payments, that is a judge telling the payer, pay this amount of money per week until somebody says stop. Carrier continue payments. This is something that workers benefit from because the payer cannot on its own unilaterally change the payments. The payer would have to come back for a hearing and have a judge change it or appeal. The payer could appeal it, and then it could get changed on appeal, and we will talk about appeals more later. This is now one of our biggest, most important topics, and we're going to be spending a good amount of time here. But my friends, this is the foundation for the indemnity benefit. It's that important. Everyone needs to know this. I think yes. As a matter of fact, we have a quiz. We have a quiz after this, after the next couple of slides. So ready? Here we go. Degree of disability. This is a very important concept because the degree of disability is going to dictate how much of the benefit possible you're going to receive. Now, the provider, the treating provider, can indicate an opinion on the worker's degree of disability. How disabled is the worker? Key question. The degree of disability is probably going to be expressed as a percentage. It's going to range from 0% to 100%. 0%, you're healthy. Yay. 100%, I'm sorry, but you're injured severely enough that you shouldn't be working. You're 100% disabled. Now, up on screen, just as a way of background, we made this table here. We're showing you on the right the percentage. On the left, we're showing you the old school way of expressing these percentages. Because, you know, back in the day, as they say, attorneys and the board and providers might use total to indicate 100%. They might indicate marked for 75, moderate for 50, mild for 25%. Okay, now let's go down a little bit deeper. Allie, before we go down a little bit deeper, are we going to have copies of this presentation for the people?
Yes, we will. So at the end of the presentation, we'll give you information about how we'll follow up and give you a copy of this and everything else.
Thank you very much. That's totally Allie's realm, by the way. I have nothing to do with that, so thank her. Okay, you got your degree of disability. How much money are you going to receive now? Or a better question would be, what percentage of the maximum possible rate are you going to get? Well, if you are total, that means you're 100% disabled, you're going to get 100% of the benefit. Now, this math is very simple, my friends. If you're 75% disabled, you're getting 3/4 of the benefit. Okay, you see how it goes? 50%, half. Whatever percentage disabled you are, that's the percentage of the benefit you can get on the top line, or the maximum amount for you, I should say. And by the way, we've been going in quartiles here, 25, 50, 75, 100, but the providers could indicate any percentage, and they sometimes do. I have seen 2/3 disabled or 1/3 disabled, so that is possible. The maximum benefit rate you're going to receive is capped at the maximum benefit rate that was in force the day you were injured. So if you were injured in 2006, when the maximum rate was $400 a week, I'm sorry, but that's going to be your maximum rate possible per week for the rest of your life, okay? We do not have cost of living adjustments and anything else that varies it from that fact. Oh, right. It's time for the quiz, my friends. So here's Allie.
All right, we have a scenario for you. So this is Susan's indemnity benefits. Alrighty, so Susan was 100% temporarily disabled and has been receiving $1,000 a week for the last 3 months. Susan's doctor recently said she is healed to the point where she is now only 50% disabled. Susan has never had a workers' compensation hearing. True or false, because of her new disability percentage, Susan's benefit will now decrease to $500 a week. So in the chat, what do we think, true or false?
So just type true or false, Allie?
That's right. I see a lot of truth coming in.
We just saw a pretty good response. We'll
a lot of trues, a little bit of falses coming in as well, but looks like mostly trues.
Including the one person who typed,
Oh, so
this is
true.
so true.
What is it, Joe?
This is true. It is true that because of Susan's new disability percentage, which took her from 100% to 50%, it is true that her benefit is almost certainly going to drop to $500 a week. I said almost certainly because if the payer wished out of the kindness of its heart to keep her at $1,000, they could. But, you know, that's a tiny chance of that happening. It's just not how things work in the system. And the key factor here is that there's no CCP. There's no order from a judge for the carrier to continue payments at $1,000 because Susan has never had a hearing. So there's no occasion for a judge to make this direction. All right, the degree of disability. Now I'm speaking more to our friends in the payer community because we do have a great number of people from the payer community on this session, and welcome. I'm so happy you're here. Oh, sorry. Well, yeah, I'm welcoming the payer community. I'm sorry, I used the wrong P word there. But there's also the provider community. I'm so happy you're here too. We're happy everybody's here. But to the providers in the audience, you play such a pivotal role, not only obviously in healing injured workers, but in helping benefits flow properly. Here's what. Here's one of the many ways. When a worker is temporarily disabled, which means nobody has said this is permanent, and so we're still probably in the first year or two after the incident date, workers with temporary disabilities must see their treating providers every 90 days minimum for an opinion on how disabled they are, for an opinion on their degree of disability, or their benefits can be halted if there's no CCP. And by the way, if there is CCP and the worker doesn't see a doctor, the payer could ask for a hearing and they could land in front of a judge without an opinion on disability, and the judge could stop the benefits because the system is based on the idea that the person's injured and the providers, the treating doctors, are the ones who say how injured the person is. Okay, so you see how all of this flows from that. So, to our friends in the provider community, would you please be sure that in addition to filing that CMS 1500 that shows who you are and what procedures you did and how much you're billing, would you please be sure to file your opinion on disability, and you can do it two ways. Here's one way that we set up for you. You can use the medical narrative report template. We created this template for you. You see the top section is all the demographic info. You see the bottom section? Those are the three big questions that have to be answered when a worker is temporary. Number one, work status. We ask you to tell us if the worker is on the job or not. Yes, no. Causal relationship. Is what you're treating the cause of the injury, and is this comp? So you're going to answer that. Here, number three, temporary impairment percentage. That's the very formal way of saying degree of disability. What is the temporary impairment percentage? And this is where you put 0 to 100%. Sign it, date it, send it in, you're done. Now, you do also have the option, if you wish to not use this, but you have your treatment notes. Yes, we understand you have your treatment notes, and we're grateful for them, thank you. But would you please put these 3 questions in your template of your treatment notes, just so you will remember to answer this question and get that info in, because this info is so important to us. Okay, everybody, thank you for listening to that one, especially the providers. The payers are obviously looking for this info too, because, and please write legibly, someone says. Yeah, if you're handwriting this, please write legibly. That's a suggestion from a member of our audience here. But the payers are looking for this info because they can't do the equation that yields the benefit if they don't have the degree of disability. All right, new topic within the indemnity world. I've been talking about all these situations where we're in temporary world. It is possible that a worker may be permanently injured. Now, that's going to be decided at the end point by the board, but we're going to use the opinions of the treating doctors, and if the payer gets an independent medical exam, well, you know, that opinion will be considered as well. So let's just talk for a moment about permanent partial disability. So it's going to happen that the worker is going to get to the point of maximum medical improvement, MMI. You're as well as you're ever going to get. So now the question is, are you permanently injured? Well, you can go down 2 paths there, permanent total, permanent partial. Permanent total disability, PTD, it's very rare in this system. Permanent partial disability is much more likely outcome, PPD. Now, what's your benefit going to be? This is what we're explaining to you on screen. The amount of weeks of benefit you're going to get on the right-hand side of that table as you look at it. The number of weeks of benefits you're going to get before you end is going to be dependent on that left column, LWEC. LWEC, that's how we all say it, friends. LWEC stands for loss of wage earning capacity. We all have a capacity to earn wages in, theoretically in this system. So if you're injured, you're going to lose some of your ability to earn wages. The more of your ability you lose, the longer benefit period you get. So you can see at the top, the longest amount, 525 weeks. The bottom amount, 225. Let me save you the math, friends. It's between 4 years and 10 years. Okay, that's what this shakes out to. So at the bottom, if you lose between 1 and 15% of your ability to earn, you're getting 225 weeks, and then it goes up the ladder to the tippy top, 96 to 99%, 525 weeks. All right, this is now continuing the thought because I know what you're thinking, and here it is. Let's say the worker has been classified permanent partial. Okay, classified is a verb we use in this system frequently. It's one of the big ones: controverted, classified, appealed, decided. Okay, these are all big verbs in this system. Classified means you're either permanently partially disabled, permanently totally disabled, or suffering a total industrial disability. So let's say you're the worker, you're going along, you're PPD, permanent partial, and during those 4 to 10 years of benefits, let's say you lost a lot of wage earning capacity. You are getting 425 weeks of benefits. Okay, that's near the most you can lose in terms of wage earning capacity. Your health very possibly might deteriorate. You might get worse as you go along. Well, if that should happen, you do have the ability to come back to the board and ask for a reclassification. You can either be reclassified to a greater loss of wage earning capacity, or more probably, you can pursue a change in condition to pursue permanent total disability or total industrial disability. Permanent total disability means you've lost 100% of your wage earning capacity. Total industrial disability is another benefit that is similar to the extent that both permanent total and total industrial will get you the indemnity benefit for the rest of your life, and they'll also get you the maximum rate that you're eligible for. Whereas under permanent partial, it's a partial, so you're not going to get 100% of your max rate. Over here with permanent total and total industrial, you can. And total industrial disability is a little different because the criteria we use are a little bit different. Things like your age, your education, your facility with the English language, the realistic prospects of you being retrained for something else, those come into play with total industrial disability. I'm calling this out to you, to workers and to providers who might want to be very fluent in this, and to attorneys who are on this call who represent workers. Last year we got 35 applications for total industrial disability. There were 170,000 new claims filed last year. 169 and change, if you really want to be precise. We can get you the exact number if you need it. But we had 35 applications for total industrial disability. This is a vastly underutilized benefit. That's why I'm calling it out. How about a best practice regarding indemnity payments? What do you think, Allie?
Yeah.
Okay, number one, you're a worker. I'm about to hear everyone in the payer community applaud. Would you please consider direct deposit if you can get a bank account? I have no idea why you want a paper check. If you can get a bank account, it's 2024, my friends. You have had to have your Social Security directly deposited for more than 20 years now. And, you know, I'm emphasizing this because I should really count how many inquiries per week we get from workers who are waiting for checks because it's Monday and they usually get their check on Friday, and where is it? Would you please just get direct deposit? Thank you. Also, if you get paid in cash and you're a worker, that's fine. You're allowed to get paid in cash, and cash is legal tender. Some people think cash is king. But let us give you a piece of advice, please. Keep records. Get yourself a notebook. Open up an electronic file. Write down who paid you, what date, how much, what did you get paid for doing. Not only can you then keep track of what you ought to be receiving, but if you ever have a comp claim, we're going to need how much you were earning. All of a sudden, you have records, don't you? Finally, please note where you were working when you were injured. This is a very specific thing that's directed towards people who work in extremely rural places, if you can get that address, but especially people who work in cities who do construction primarily, day laborers, and to the attorneys who might represent them. Please keep track of the address where you were working. Just note it. It's a really good thing to note, just generally speaking. But let's say you got injured and you're filing a C3 and you're on a construction job in Midtown Manhattan. Okay, this happens all day, every day. There's a vast world of difference between telling us you were injured at 777 East 39th Street versus, you know, just below Times Square. There's a vast world of difference. And the difference comes down to the fact that if we know the address, we can pull the building permit. And if we pull the building permit, we know all the generals, all the subs. It's so much easier to figure out who's the payer here. And also, if you're an attorney representing the worker in this situation, please spend the 30 minutes getting the proper address and then putting it on record so that we could save you months of hearings. All right, I'm going to take a drink of water, and then we're going to do the big one here, labor market attachment. Thank you for your patience. There is a concept in the New York State workers' comp system that, by the way, is not in almost any other workers' comp system in the United States. It does appear in Virginia's, though. I can tell you that reliably. I've seen their standard. But there is this concept in the New York system that says workers who are temporarily disabled. Remember we spent all that time, Joe kept saying temporary permanent? Okay, we're in temporary world now, and you're less than 100% disabled. Okay, so that's partial. You are what is called temporarily partially disabled. Temp partial. You ever hear the term temp partial as contrasted to temp total? Okay, it's either temp partial, temp total, permanent partial, permanent total. If you're temp partial, you have an imperative to seek employment within your physical job restrictions to continue your indemnity benefits. What? Yes. If you are not working, remember, if you're not working and you are temp partial, the payer could ask a judge, this has to come from a judge, it doesn't come straight from the payer, has to come from a judge, which means it's happening at a hearing. The judge might say, yes, would you please demonstrate your labor market attachment? You're attached to the labor market, which means you're looking for employment. Okay, you have to do this if they ask you to do this, my friends. So what is now the standard that we're going to use to decide if you are looking sufficiently for employment? Well, it's in the third bullet there, in green. Timely, diligent, and persistent work searching. Okay. Forgive the English professor in me, but that's one adverb and two adjectives. Okay? If you're looking for a number of applications you have to file, there isn't one. If you're looking for dates, if you're looking for something that's quantifiable, there isn't one. We use this subjective standard. So the type of the work search is known, but the amount, well, that's going to be decided at a hearing or on appeal if that's what happens. So now let's talk about how the workers do this, what resources they have. Here you go. This is all coming from a decision known as American Axle. Okay, so if you're given to, you want to look up that decision, go on ahead. It's called American Axle. And in American Axle, they laid these options out. Here they are. Number one, workers, you may use Department of Labor reemployment services. Go on ahead. I wish you the best of luck. Make a note because you're going to need to document all of this stuff that we're showing you, but we'll tell you how to do it. You can also go to the Department of Labor one-stop career centers. Okay, the staff there can help you with searches, and they can do follow-ups with you on any matches you might make, and they have seminars and orientation and counseling. Very helpful. I encourage you to do these things. You can also take advantage of vocational rehabilitation, Voc Rehab, via what's known as Access VR. If you've been around a while, you might remember VESID. VESID is now known as Access VR. Okay, so these are services that you can use to help find a job. The other thing you can do that we're talking about right now is you can go to college. Full-time higher education. Full-time higher education or training. If you don't have a college degree and you want to go back to college full-time, go on ahead. Fill out a FAFSA. See if you can get financial aid. A little tip from me to you. So, if you're on comp, how much money are you really bringing in? Maybe you want to fill out. So anyway, point is you can enroll in college full-time and then tell the judge, and that's one way that you can meet this test here. You're going to want to fill out and record these efforts on Form C-258. That's that form that we're showing you right there on screen. We have a form called the C-258. The point is, if you do these things, you must record them and tell us about them and get them into your file. And we're urging you to use the Form C-258. Also include a resume in your board filings. Now, we're going to go to the next item. Here's where your resume is really important. Definitely include a copy of your resume, okay? Just trust me on this one. It just demonstrates so much about your work search. We're not going to necessarily critique your resume, not necessarily, but the fact that you have one and you're showing us you have one and you're using it, that's a very good thing. You can do what's called an independent work search. That means that, you're looking for a job. You're pounding the pavement. You're showing up in person, maybe. Practically nobody does that anymore, and that's okay because everybody's using online resources. Go on ahead, use the online resources. Just for goodness sakes, please tell us about them. Now, we have another form. You can use as many forms as you need, my friends. This form here is the C-258.1. And this form you're going to use to document all of your online applications. So you're going to fill in the blocks, and I really urge you to do this. And you know what? If you're applying to 10 a day for 100 days, that's 1,000. Okay, just get as many copies of this form as you need to file 1,000, okay? Just record every single one and, include the application date and what position you applied for. What site were you on? Were you on Indeed or Monster or Glassdoor, or did you go through LinkedIn or one of the other 1,000 different sites? Did you work with a recruiter? You need to give us the information. Give us too much information. Here's a good idea. If you think that, maybe, do they really want to know that? Do they really want to know the URL of what I applied to? Probably yes. Okay? And then put that on the C-258. If you get an email confirmation, file that too. And just file everything and keep doing it until you have your next hearing. Okay, if you're a worker, sometimes workers send all this stuff to their attorney. Work it out with your attorney, whether you're going to do that or whether you're just going to file it yourself at WCB claims filing at wcb.ny.gov. I think we have this later on for you. You can file stuff yourself online. Just put your claim number in the subject line. Okay, so that's what I want to say about labor market attachment, LMA. Just take it seriously, my friends. Do it, record everything, file everything. Don't stop until somebody tells you to stop, okay? Don't stop until someone in authority tells you to stop, like your lawyer or a judge. New topic. There are penalties for late payment. So you're a worker, you're getting payments, it's late. Well, what is late in this system? Here we go. When you first get injured, the benefits, assuming that you are qualifying for benefits, you can't work, degree of disability, the benefits should be paid within 18 days of incident or 10 days from notice, whichever's later. So, do you remember in the 101 when we said, what's the chain of events that happen? Number one, you have an incident. Number two, you tell your employer you had an incident because the employer tells the carrier or the payer now has the 18-day clock running. Okay. Let's say a judge makes a decision to award you benefits. There's going to be a piece of paper generated. You might get it electronically. You might see it electronically. You'll actually get the piece of paper by us via the U.S. mail. But if you look at that decision, look in the lower right-hand corner, there's going to be a filing date on that. It's going to be a day or two or three after you had your actual hearing because we have to prepare that piece of paper. That's the filing date. Money should be sent to you within 10 days of that date. That's why I'm telling you to get direct deposit. Because if you've been on direct deposit, it's going to be deposited within 10 days. You don't have to then have a postmark 10 days later, and then it has to arrive, then you have to get to the bank, they have to clear it, la-di-da-di, okay? If you also are receiving payments every 2 weeks, that's what we call ongoing payments. Those payments are not late until they're 25 days late. That's 3.5 weeks. You know, after 3.5 weeks or 25 days, you could qualify for a penalty. Same way if it was mandated that you be paid and, okay, 10 days from filing date, yeah, you could qualify for a penalty in that respect. And also, if there's an appeal, interest is due in some circumstances if the worker is due money. So payers, let's make sure we are calculating those interest payments. Thank you. We are more than halfway through our session, my friends. We are now turning our attention to medical care. I know you have questions about questions. What do I do if I have a question? Well, here's what you do. You're going to type it in the chat. You can type it now, or you can type it later. If it pertains to what I'm talking about at this instant, and I see it and I can't answer it, I might. Otherwise, we're going to save them for the end. Allie and I are going to go through all of them. All right, now we're on medical treatment. There is something in our system known as the Medical Treatment Guidelines. This came about also as a result of the 2007 reforms. We have these guidelines that we're about to show you that pertain to 16 different elements of medical care, I'll call it. As in, some of them pertain to parts of the body and the treatment therein, and then some of them pertain to specific disorders, such as mental nervous disorders or eye disorders, traumatic brain injuries, okay? The point here is we do have these medical treatment guidelines. They're out here online. We have all kinds of training, okay? See on the right, we have both the guidelines, and the next box down is training. If you're a provider, yes, please take advantage of these resources. We have a lookup tool, which is so great. We have courses on it. And if you're a provider, you're going to need to become familiar with these things because this is going to prevail and pertain to how you're treating. And we are bringing this to your attention now for several reasons. Here we go. Number one, it's the providers who file for prior authorizations. Not the workers, not the lawyers. This is all about providers. We have this new system called Onboard, okay, that the providers can access, and prior authorization is known as a PAR. PAR, that stands for Prior Authorization Request. Providers are going to ask for PARs in specific instances. Here they are on screen. Number one, medication. We have a formulary. It is possible that under the formulary rules, you may have to ask for an approval for a specific drug for a specific usage. Okay? That's one type of PAR. Second, now we're in treatment, the other side of treatment now. If the treatment you're desiring to perform costs more than $1,000, you're going to have to ask for authorization before you do it. And the other one, the most prevalent one, is if your treatment varies from those medical treatment guidelines. It varies, so you're going to ask for a variance. There is a review process of these PARs. Now, we are going to talk to you about that review process. Number one, we have, or I should say level 1, level 2, level 3, 3 different levels. Here is the level of, what we're showing you on screen, sorry, is what happens in a treatment PAR, okay? So you want to vary from the guidelines or your treatment is over $1,000. The provider completes the request, files it. It's going to be reviewed at the payer at level 1. Level 1 is almost always, it should always be some medical professional. I say almost always because I don't know if it's mandated that it must be, but I've never seen someone who was not a nurse or some form of a medical professional do the level 1. Okay, so let's say that the level 1 approves. Great, go get your treatment. Let's say, though, the level 1 denies. Okay, we're in treatment now. We're not in formulary. We're not in drugs. We're in treatment. Level 1 is automatically escalated to a physician at the payer. So it has to be seen by a physician now, MD-DO. And with the much greater expertise and experience and everything else, the physician very possibly might say, yes, approved. Okay, great, go get your treatment. You don't need anything else, my friends in the provider community. You've just been approved. Go get your treatment, please, or render treatment in that case. However, let's say that the physician denies. Level 2 denial. In each of these instances, the reasons for denial will be spelled out on the paper. They have to be, and they are. So now you're the physician who's prescribing this treatment or who wants to do this treatment. You're going to have to read that and make a decision. Here's the decision fulcrum you have. Did I actually provide everything that they're saying I should and they're denying me? If you think you actually did provide everything and you want to stick with what you said, escalate it within 10 days to the board's medical director's office. You have to take this affirmative step to go back in and do the right functions in onboard to escalate it to the medical director's office. They will review it. They will review it very, 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 very quickly. We're talking days, okay? When we first went live with this a year or two ago, yes, it took longer. Those days are long gone, my friends. Let that go. You're going to get your decision in a matter of days. And if the MDO, the medical director's office, says, do the treatment or the treatment's authorized, you can go get it with a clear conscience. If they deny it, do you want a hearing? For some reason, if you want a hearing, you can get one. Now, this is all in the treatment PAR. Just want to call out. The same process prevails for medication under formulary. It's just that the difference therein is level 1, okay, if it's denied, the prescriber has to escalate to level 2 on a formulary. Maybe we should put that on the slide for the next one.
Yeah.
Okay, the prescriber must escalate for level 2 in formulary. And then if that's denied, if you wish to still stick with what you submitted, the prescriber must escalate to level 3. That's the difference in formulary. Also in the files, if you do eCase, you'll see the PARs for treatment are going to be MG2, and the formularies are going to be RX, the obvious RX. All right. Best practice for workers. You're seeking medical care, as you probably should. Okay. Give your doctors a fighting chance here. Arrive at the appointments with your WCB case number. That's the number we assign. It's going to be no more than 8 characters. If it's a new one, like from the past 15 years, it's going to start with a G, as in great. If you're a volunteer firefighter or ambulance driver, did you know this? If you're a volunteer firefighter, it's going to start FA. And you're an ambulance driver, it's going to start AA, and then you'll get 6 numbers. Yes. Okay. So anyway, that's how we do it. The insurer is also going to give a number. That number is going to vary by however the insurer wants to do it. So it could be short. It could be 16 characters, like a couple of commercial carriers I know do, because I don't know if they have so many. But also bring the insurer name. So please show up with that information. Give it to your doctor. You know, they need this in order to file and to bill. Give them a fighting chance here. Let's talk for a moment now about a sort of related topic, independent medical exams. Why are some cases not assigned a WCB number? Because, Allie, I was reading the question that just came in. Why are some cases not assigned a WCB number? Because that's not a true statement. If it's a claim, it has a WCB number. Okay? All claims have WCB numbers. Independent medical exams. Okay, this is an instance when you're a worker and the insurance payer has asked you to see its doctor. It's almost always going to be a physician. It might be a psychologist if it's a stress claim. But it's going to be that level of professional in terms of training. And here's what you need to know. Number one, there's no doctor-patient relationship here. That means all the privacy and all the confidentiality you get when you see a treating doctor, sorry, it's not here because this professional is not treating you. This professional is not going to be giving you treatment recommendations directly to you. That's number one. Number two, what that also means is anything you say can land in that report that's going to be generated. Anything you say. And it can also be heard differently than you intended or even said. That happens too. So you may bring a witness. And no one can tell you no. Even during COVID, you were still allowed to bring a witness. Anybody says, no, you can't bring your witness, you tell me, we'll get to that in a moment. Now, your witness or anybody, well, your witness or you, it's probably best done by the witness, may record the IME, video and audio. Yes, they may. No one can tell you no. This could be helpful to you because you're going to get a copy of the report. You're going to hopefully read the report. If you have an attorney, the attorney's reading it for sure. But you might as well read the report because now you're going to be thinking, did everything, well, you're going to be thinking, can I remember where everything that's in this report is coming from? And if you don't remember, like there's a finding, a test, that said, okay, your range of motion with your right arm is 120 degrees. So you should be thinking, did I lift up my arm? Did somebody monitor how well I used my arm? This is when you go to the tape. This is when you go to the videotape. As people a certain age from New York might remember, someone saying, yes, you can play that recording that you made and see where these findings are coming from. Yes, the provider can record, sure. If the worker can do it, the provider can do it, yeah. Now, let's say you're not understanding where this finding is coming from in the report. Well, if you have an attorney, tell your attorney, because the attorneys are very knowledgeable here. They're not doctors, but they're very knowledgeable, and they might be able to say, okay, you see when you did this, that's actually the test for XYZ. But let's say nobody can identify where these findings are coming from. You can file a complaint with the Advocate for Injured Workers. That's me. So you can file complaints about IME conduct. Now, by conduct, we do mean you don't know where these findings are coming from, or you were treated in an unprofessional manner, you were not seen in a medical facility, your wheelchair did not fit into the exam room, so they examined you in the waiting room. That happened, okay? These are examples of conduct. If the IME said you're 0% disabled and your doctor says you're 100% disabled, that's not conduct. That's a difference of opinion. You have to litigate that. But based on the examples that I've given you regarding conduct, and you can always check in with us and ask us, you may make your complaint to my office. We'll give you the email address in a moment or two. I will read it. I'm the one who has to go through these. And there's a very high probability that I'm going to be passing it on to the IME committee, who's going to review it, who has the authority to, well, in the most dramatic example, they have the ability to remove the license of the IME entity to operate. That has happened. Most recently, that happened 2 Februaries ago. So we do take these pretty seriously, and we do investigate every single one of them. I can tell you that reliably. Finally, with respect to IMEs, your due travel reimbursement, my friends. File your C-257s, get your travel reimbursement for these trips to and fro, especially considering the distances that workers with severe injuries are sometimes asked to travel. So this is my plea to the payers in the audience. Can you please try and get the worker to an IME a lot closer to home? Thank you. All right, we're getting towards the end now. Let's talk about appeals. Judges' decisions can be appealed within 30 days of that filing date. Either party, the worker or the payer, can appeal it. If you're a worker and you have an attorney or representation, your representative's filing the appeal, okay? Please let your legal representative handle this, okay? That's why you have that person. They're expert in this. The appeal is going to be decided by a panel of 3 board members. We have an actual board of 13 people called the Workers' Compensation Board. There are 13 individuals. The chair of the Workers' Comp Board, Clarissa Rodriguez, okay, she's who I report to directly. She's the chair of that board, as well as the head of the whole agency. They're going to make the decision. Let's say a judge awarded you benefits and the payer decides to appeal that decision. Well, we are an unusual system in New York in that there's an automatic stay on paying benefits. It's automatic. Payer doesn't have to do anything else. They don't have to pay. That's unusual in New York. But they don't have to. So if the panel decides benefits are due, the benefits have to be released at that point, and they almost certainly will be. I've only seen one instance in all my time where a payer did not agree and did not release the money. And we hit that payer like a ton of bricks. So the money's going to be released at that point. It is possible that either party can appeal the decision of the 3 board members to the full board. 13 people now, okay? You can appeal to all 13. Here's how that goes. If the 3 panel members split, if it was 2 to 1, it is automatically going to the full board. So you don't, you should file your arguments, but it's going to the full board. If it is a unanimous decision, but one of us wants to dispute it, one of the sides, fine, you certainly can. That's a discretionary appeal. Good morning, Tony. And so now the board has a choice. Are they going to hear it or not? That's why it's discretionary. From there, it can go to the New York State Supreme Court Appellate Division, 3rd Department. That means you have left the workers' comp board. You're now in court. We don't operate courts, my friends. We have hearing points, we have hearings, but they're not courts. Now you're in court. And by the way, there's a small, well, some people might consider it small, fee to actually go to the appellate division. Our decisions and so forth are free. There's no charge. We don't charge you. So after the panel, the 3 panel members, here's what can happen. You can skip full board and go right to the appellate, but that's rare because the full board is free. But you can. Now, if you still don't like the appellate division decision, you can actually go to the Court of Appeals above them. That's very unusual, but it does happen occasionally. And then from there, if you really think you can get your appeal accepted by the United States Supreme Court in Washington, that's your last stop. I only mention that because our historical friends will know that the very first comp claim actually went to the U.S. Supreme Court. And the U.S. Supreme Court decided, yes, workers' comp is allowed in the United States of America.
Also, this webinar is live, folks.
Yes. Okay. What is a settlement? This is our last major topic, although we do have something very helpful to say after this. What's a settlement? I hear this term used a lot, and people seem to have these ideas about settlements. Let me tell you what a settlement really is in our system. It is a Section 32 waiver agreement. What's that? Well, that is a contract that a worker and a payer would strike and sign between themselves, and that would have to be approved by the board. That's going to permanently, you can't reopen it, permanently close either the medical care or the indemnity or both in exchange for payment now. Okay, this is what a settlement is in our system. It's also forever. So you better know what you're doing, my friends, on both sides. What we're showing you right now is the page on the website where we have some info about settlements. We also have a video on this on our page that is very helpful and instructive that you're going to have to watch, by the way. It's part of the rules that you have to watch the video. There it is right there. I'm very excited about it because I wrote the script like, I don't know how many years ago, back when I was in PIO, like Allie. Okay, so point is, you can't reopen it. You can settle the medical, you can settle the indemnity, you can settle both if you wish. Workers, if you're settling your medical, just want to ask you, did you consider how you're going to get treatment after your money is spent? Because you will have to set aside money for the treatment. You can't buy a Corvette with that money. You have to spend it on treatment. But what are you going to do if the money's gone? How are you going to get treatment? Okay, that's just an honest question to ask you. Finally, this is optional. We can't compel either side to accept it, so please don't ask us to. Our only role at the board happens through a judge at a hearing. I have no role in this. Allie has no role in this. It's going to come to a judge, and a judge is going to review it and either approve it or reject it. The only times we reject these, though, are if, number one, the agreement itself is legally unsound, or number two, it is unconscionable. The terms are simply unconscionable. How do you find representation in the form of an attorney or a licensed rep? We cannot give you a specific name, but we can give you the resources. Number one, right up there on screen, you can call the New York State Bar Association, tell them you'd like an attorney, and they'll give you names. There's also the URL there. There is a group of attorneys who represent injured workers in this state. They're known as the Injured Workers Bar Association. You can call or visit their site. They will also give you names. We at the board occasionally hold an exam, and we grant a license to extremely knowledgeable people who are not attorneys but who passed that exam to become licensed representatives. We have the list on our website. Just look up representatives on our website and you'll find the list of licensed reps. I've seen this exam. It's pretty stiff. Finally, let's say you're a worker. Let's say you have a medical only. You have no indemnity. You're not losing time, but you have some issues that are going to require a hearing, medical only. You can visit the Bar Association and select workers' comp on the left side of the page. They'll get you a pro bono attorney, an attorney who represents you for free. You know, Allie, as long as I'm given resources, I'm going to make a pitch because one of our friends in the chat has indicated he or she is seeking employment. New York State government is hiring. We're hiring like mad, and we have this new thing called New York State Helps, where you don't need to take an exam anymore for some positions for a period of time. So this is just me telling anyone who's seeking employment, who's with us right now, who might want to work for New York State government. Thank you, Jessica. Thank you, thank you, thank you. Go to statejobs.ny.gov. Jessica typed that into the chat. I love how helpful everybody is on these webinars. Yes, so if you want employment, statejobs.ny.gov. Check out what's available to work for the great state of New York. Allie and I, am I being presumptuous, Allie, or would you recommend state employment as I would?
I sure would.
Okay, there you go, my friends. Now, back to the last regularly scheduled topic, virtual hearings. Yes, we have announced we are going to resume the in-person hearings in the autumn, but we're going to continue doing the virtual hearings, and this is what we have until we go back to in-person, by the way. The virtual hearings, they saved us. They saved the whole system when the pandemic struck. Do you remember the pandemic? Do you remember March of 2020 when all the court systems closed down, except, well, our hearing system didn't close down. We just kept going because we had virtual hearings. So what we do is we use what is essentially a teleconference, or what we now call Zoom. We don't actually use Zoom, but that's how we do it. We have an app. Okay, the app is available from Google and from Apple. You can download it, or when you get your hearing notice, you're going to get the directions with the URL. URL is what old-timers like me call the website. You're going to get the web address to go to. You're going to get your password and your code. If you don't want to do it that way, you can participate by telephone. It's just that if you want to participate by telephone, you need to tell us ahead of time because the judge calls you. The judge calls you. Okay? If you're a worker, I'm encouraging you 100% join your hearing. Okay. Now with that, oh my gosh, we're moving into question time, aren't we? All right, here are our social media presences. We don't send frivolous content. As much as we might enjoy it, we have to go somewhere else for that. But we are state government. We are sending you formal, important content. I'd like to call out the fourth one down, YouTube. How many videos do we have on our YouTube?
Hundreds. Hundreds of hundreds.
And what do we do with the recordings of these webinars?
Yeah, so we post the recordings of these webinars on YouTube for everyone to watch after. If you want to rewatch this one, if you want to rewatch past ones or ones on different topics, they're all up there.
Very good. Oh, pardon me very much. Now, this is the information for contacting my office. If you wish to contact my office, here you go. There's your phone, there's your email. It's the Intuitive Advocate for Injured Workers, and there's our website. If you come to our website and you put Advocate for Injured Workers in the search bar, you'll come to our page. We have a lot of really good stuff on our page. Allie and her team put all kinds of really cool stuff there, including these videos constantly. We're making these 1-minute videos. So I encourage you to check that out. Other than that, Allie, what do you think? Should we do some questions?
I think we're ready for questions. I'll leave this slide up on the screen, so if you need to refer back to it for our Advocate for Injured Workers information, it's right here, but we will start addressing your questions. All right. Is authorization required for medical providers?
Yes and no. Yes, in New York State, if you have an emergency, you can see an unauthorized provider, sure. If you see an unauthorized provider and it's just part of your claim, you know, the payer may or may not object to that. But within New York State at the moment, yes, authorization prevails.
All right. So next is, how is the payer notified without board intercession?
I'm glad you read that one, Allie. I don't quite understand it, though. Do you?
I think it might be in relation to the question, the poll question we did, but I'm not sure.
Yeah, it's right around that time. Mm-hmm. Okay, so to our friend whose initials, first initial R.
They might be replying. Let's see. Correct, it was.
Oh, it was around the, thank you. It was around the poll question. The poll question has, okay. So the poll question, you might remember, was we had a worker who was going along at 100% temp total and then got a medical that said temp partial, 50%. So the payer dropped the benefit. And so the question now is, how is the payer notified about this? Oh, okay. Well, here's how. Remember that claim folder we talked about? Remember eCase? Well, when I said if you're a worker and you register for eCase, you can see what we all see. By we, I meant the board. I also meant the attorneys and the insurance payer, because the insurance payers absolutely, they see your file because they're responsible for what's in your file. So if something lands in your file that they have to act on, they're responsible for acting on it. So they're going to know about the change in your medical status.
All right. Is the PPD benefit paid in a lump sum payment or weekly payments?
Weekly. The weekly payments that arrive biweekly. But yes. Oh, okay, that's a good one.
All right, so someone had a question about the New York State job. So is the licensed representative exam still being offered?
Okay, we don't have one scheduled. That's an exam that is not going to be covered by New York Helps because that's, remember I was talking about the licensed representatives who can represent workers? You need to take that one so you can get the license to represent the workers because you're not an attorney, and we don't have one scheduled right now. But when we do have it scheduled, then it will be. That's two questions. Let's do them one at a time.
All right. So first question, do your medical providers and your attorneys have total access to your eCase file?
Attorneys, yes. Medical providers, no. They're limited to the treatments they're performing. Although if you're a worker and you have a report from, Dr. Price and you're standing in front of Dr. Vincent, you certainly can hand Dr. Vincent the other report if it's going to help your treatment. Don't worry about that. You're the worker. It's up to you.
All right, so the second question is the MDO approves medication and the pharmacy states that they cannot fill the RX because approval has been delayed by the carrier. What should you do?
Call us right now. Call us right now. Can I be any more emphatic? Call us right now. That cannot happen. We need to know about that because we will jump all over that. So my friends in the payer community, there is no instance where that is possible. Make sure, please, it doesn't happen because someone's medications are being delayed. That's someone's health.
All right, so next question. For providers, are there specialized billing companies that deal with workers' comp?
Yes, actually. I personally don't have much more information for you beyond that. But yes, there are what are called clearinghouses who you can, as a provider, contract with, and they will file everything correctly and properly for you. I'm going to recommend that you go to our website and look up clearinghouses or play one of our recordings of some of our provider webinars because we do cover that topic. Yes, that's a good one, Allie. Oh, my gosh.
All right. Are medical providers responsible for sending their bills and records to the carrier, aka payer, via mail so that the adjuster is kept updated?
You're probably a worker, aren't you, who's filing that question? And that's perfectly fine. All right, here's the answer. Number one, no, you don't have to do it via mail. That implies U.S. mail and paper. We're actually hoping you're not using paper because that's the longest, most expensive, least reliable way to do this. But yes, you can still use that. Okay. Are the providers responsible for sending their bills and records to the carrier? Of course they are, because they're not going to get paid for their services if they don't. Okay? I understand the worker is waiting on some things that are going to happen after that gets filed. Very true. But you better believe that the payers have all kinds of incentive to do this properly and timely because they're not getting paid for their services if they don't. Yeah.
All right, we have a scenario. An associate is going out for a work-related injury and is going to be collecting lost wages. He is also qualified through New York State paid family leave and is getting paid 2/3 weekly wage while out.
Okay, we can stop right there, Allie, because no, you can't have both. If you're so injured that you can't work, then you can't take care of another person under paid family leave. So no, you can't have both for exactly that reason.
Alrighty. Must all settlements or Section 32 monies be paid via paper check?
No, if you're set up for direct deposit, you can get it via direct deposit.
Alrighty, that's all the questions we have for now.
Do you want to give them a minute?
Yeah. We'll give you one more minute just to see if there's any more questions that come in.
Do you have any webinars or anything you want to pitch?
Workers' Comp 101 webinar is tomorrow. If anyone here is thinking, I'd like to get the background more on the high level, we have that going on tomorrow at 11. And keep updated on our website. We have a webinars page with all that good stuff.
I think we have a clarification.
Okay. Someone said PFL allows for COVID on the employee if contracted at work. It is also comp.
Okay. Thank you for the clarification. So now we're getting into time, as in you got PFL, and you contracted COVID, and it's work-related, so you're going to get the PFL COVID benefit. All right. But that's all you're getting for those 2 weeks. Now, you still can't work? Okay. Your COVID benefit via PFL ended on day 14. Now your comp picks up day 15. Okay? So you see how that is? The timing there was the missing element.
Next question, are adjusters obligated to check eCase for medical and work status daily in all of their New York claims?
Daily? I don't know the law that says you have to do this daily. Let's just go with what I said before. If something's in the file, the payer is responsible for acting upon it as required, as necessary. If you're an injured worker, you might have a different impression of how quickly it should be acted on. You might have a different impression about whether it should be acted upon in a certain way. And if you contact us or you contact the payer and the payer doesn't wish to do it, well, you very possibly might have the option of a formal hearing or a formal decision directing it one way or another. You might not win, though. But that's okay if you don't win. There's no penalty. But just letting you know, we could have a difference of opinion there.
Is there a penalty for an employer not reporting a case to the Workers' Compensation Board or insurance carrier?
You better believe there is. That's a pretty significant penalty. So if this happens, you need to tell us. Okay, but yes, there are penalties. This stuff does have to be reported. Okay, yeah, please read that one. That's quite a sitch.
If a PAR was submitted by one doc and approved, but treatment was never done, and then it was submitted by another doctor and denied because it was previously approved, can the new doctor use the same PAR approval to do treatment?
I think so. I wouldn't focus too much on the denial of the same thing by the same person. I would just focus on, the fact that it was approved. You can, the doctor can always check with our medical director's office. There's not like this specified length of time for how good the PAR is good for, but there are some reasonable thresholds that you would know if you practiced medicine. If it was approved over a year ago and you're looking to do a surgery, we're at the point now where you practice medicine, you understand these temporal elements more than a layperson like me would. So there's that too. We have penalties of all different amounts, okay? One of our friends is asking about penalty amounts. They're all different amounts. Okay.
What's the best way to address a duplicate treatment request denied at level 2 review when re-review is not warranted?
All right, so are we back on it was approved already and now it's being disapproved because it's already been approved? Look, we're starting to get into like the weeds on this one. You need to call the medical director's office. If this should happen to you in this rather specific, rather unfortunate bureaucratic incident, contact the medical director's office. You can call them or you can email them, same as you can do my office. They have the same. I really should commit that phone number to memory.
Me too.
I'm sorry that I don't. I know that the email is MDO, as in medical director's office. I know it's MDO@wcb.ny.gov. We're going to probably get you that phone number, but yeah, you can use MDO@wcb.ny.gov. Okay, well, we're getting that for you. Do we have it? Okay, go ahead. Give us that number, please, Will. Okay. Well, we're going to give you another question, and then we're going to give you that phone number because we want you helped.
Is there a penalty to employers who do not complete the C-240 and the C-11 forms?
Yes.
As a carrier, sometimes it is very difficult to get these forms completed in a timely manner.
You know, I don't like to argue, but I'm really sorry. You have to be able to complete that form. We give you such great lengths of time to complete these forms. Please get them done, okay? Yes, there can be a penalty. It's not frequent, but there could be. But you get such enormous lengths of time to fill in these forms. Please try and get them done on time because the worker could be without any income waiting for that form. Now, we do have the phone number for the MDO.
It's 1-800-781-2362.
1-800-781-2362. Thank you very much. Oh, yeah, very good. And we just,
If a PAR has been denied by the MDO, but an IME later says it's appropriate, does a new PAR have to be submitted?
Yes. I'm terribly sorry. I'm terribly sorry that you have to do that paperwork, but you do. So, yes. I'm so glad that we're getting all these medical questions. Just want to reiterate, we definitely do these webinars for providers, so please feel free to join one.
All right, that looks like all the questions we have.
Okay, we're going to give you just another moment if you have any, and if you don't, in a moment, Allie's going to say goodbye. Just want to remind you, we do have the 101 tomorrow. If you can't get enough of us. The 101 is at a much higher level, by the way, but...
All right, thank you, guys. I will wrap it up. Thank you, Joe, and to everyone for joining us today. Just a reminder, you can also sign up to receive workers' compensation news, including information on future webinars, straight to your inbox. To sign up, visit the workers' compensation website, wcb.ny.gov. Scroll down to the bottom of the homepage and select Get WCB Notifications. We also distribute information on all of our social media channels that Joe featured, so please follow us on social media, Facebook, X, Instagram, YouTube. We're all on that. Thank you all again for joining us, and enjoy the rest of your day.